Okay, here we go. Thank you. Thanks, everybody. I know it's right after lunch. Folks will be trickling in. Apparently, there's something after our panel as well. But okay. But with that, let me just jump in because it's action-packed. We have a lot to talk about, and I want to make sure that all the panelists have sufficient time to say what they want to say. And so with that, I'll go with introductions, but they'll be very short. That doesn't mean I didn't want to spend more time on that, but that'll get us to our remarks more quickly. So first, let me introduce Ling. She's the managing director at NERA. She has a wealth of experience, particularly in litigation and serving as an expert witness in antitrust matters. And next, we have Dale Collins. And Dale is now an adjunct professor at Georgetown Law, but before that, he was certainly well-known as a longtime partner at Shearman and Sterling. Then we have Kristen Limarzi, who is partner at Gibson, Dunn, and she was, previous to that, section chief at the DOJ's Antitrust Division. And finally, we have Michael Salinger, who's a professor of economics at Boston University's Questrom School of Business, and previously served as director when I was at the FTC in the Bureau of Economics at the FTC. So with this distinguished panelist, let me jump right in. We're going to do a little bit of a Washington Week sort of format. I'm going to throw a sort of a meaty topic to each of the panelists, and then they're going to really tee up the discussion and the context. So with this, let me start with Dale. And I want to talk about two very different types of cases, and Dale, you're going to walk us through why they came out in a very different result, and I think that's going to be really helpful for everyone. So the cases are Epic versus Apple and Epic versus Google. Obviously, they were decided very differently, and so I'm going to ask Dale to set up the context for these cases, their outcomes, and obviously, both from a litigation and analytical perspective, why they came out to where they came out, and is there any way to reconcile them or not? So with that, Dale?
Thanks, John. I've got, 5 minutes to do this?
5 to 10, 5 to 10.
Well, I was just joking on that because I'll mention in a minute that one of the opinions in this case is 195 pages in Westlaw. It is the longest opinion I've ever seen in Westlaw. Now, others may have seen longer ones, but I haven't. All right, so I'm going to set this up. Probably most of you are familiar with this, but just to make sure everybody's got the basic background. This is all about basically the app stores on Google and Apple. Okay, and we'll start with Apple. Apple's App Store came into existence in July of 2008, and Apple put in 3 requirements. Okay, there was a requirement that app developers had to distribute their apps on the iOS system through the App Store. App developers had to use for in-app payments. They had to use the Apple in-app payment system, and finally, they were prohibited from putting basically referring users on their apps to payment systems outside of the App Store, an anti-steering provision, if you will. A couple of months later, about 3 months later, Google opened up its Google Play Store and basically adopted exactly the same restrictions. Okay, so back in 2008, when it was, I think, Apple was pretty upfront about this. They thought there weren't going to be very many revenues from the App Store. They had a commission rate of 30%, which was automatically deducted from the payment through the Apple in-app payment system. Same thing was true with Google. Neither one of them thought there was going to be very much revenues. They turned out to be wrong. In 2003, the revenues earned on Apple were about $90 billion. And the one on Google was about $47 billion. Now, that's the total revenue, so you can estimate what Apple and Google were taking by taking about 30% of that. You might want to discount that by a little bit, but we're talking about really big bucks. So, fast forward to 2020, and Epic Games, which is the developer of Fortnite, one of the big gaming programs, Tim Sweeney, who was the CEO of Epic Games, didn't like paying the 30% on either Apple or Google, and you could understand why. Over the lifetime of Fortnite, the trade press estimates that the in-app purchases on Google and on Apple were over $1 billion. So a lot of money was going to the app, to to Apple and Google and not to Epic. So Epic wanted to basically do its own app, its own in-app payment system. And that was prohibited by the developer agreement. Now, what Epic could have done is they could have just sued at that point and sought a declaratory, judgment that the restrictions that Apple and Google had put in place were anti-competitive and therefore non-enforceable. Okay, they decided not to do that. They created something called Project Liberty, and Project Liberty had, well, I'll call 3 aspects to it. So the first aspect was they did a hot fix on their apps. That is, when you've got your phone, right, you see your apps are updating every now and then. Well, that's a hot fix. And they did a hot fix that clandestinely put in a link to their own payment system. So once the hot fix was triggered, you could now, if you were a Fortnite user, you could press a link in the Fortnite app, and it would take you out of the iOS system and into an alternative payment system, unquestionably in breach of the developer agreement. So that was the first thing they did. The second thing they did was they lowered the prices on basically the non-Google, non-Apple platforms for their merchandise, their in-app purchases. And the last thing they did, and we'll do a little respite on this, is they did a video. And I'd like to show you the video. See if it comes on. Maybe it won't come on. There we go. It'll start in a second.
Of the platform unification directives. For years they have given us their songs, their labor, their dreams. In exchange, we have taken our tribute, our profits, our control. This power is ours and ours alone. We shall prevail.
Now, for those of you in the audience who are like me, sort of the old elephants in the room, you will recognize where this commercial came from. This is the Apple commercial that was shown in the 1984 Super Bowl. It was at least modeled after that, when Apple introduced the Macintosh computer. And this was, many consider this to be the most famous ad that's ever been shown on a Super Bowl. Epic took that ad and basically replaced all the images that used to be representing IBM with now Apple, and ran this ad. Okay, so that's sort of the setup here. Now, all this was triggered on August 13, 2020, and hours later, just a couple of hours later, both Google and Apple removed Fortnite from their App Store. Now, what that did, just to be clear, and this is going to be important in a second, it just removed the app from the App Store. It didn't take the apps that had been hot-fixed off the operating systems. Okay, so if you had a Fortnite app that had the hotfix installed, you still had the link outside, and that continued to operate. Okay. Anyway, as I said, Apple and Google took the apps off. And a couple hours after this, Epic sued Apple and Google in the Northern District of Illinois, 2 separate complaints. This is all on August 13th, all of this happened. 2 separate complaints that were essentially identical as far as the fundamental facts were concerned. They had the same theories of anti-competitive harm, and they basically had the same counts. There was one more count. There were 10 counts in the Apple complaint. There were 11 in the Google complaint, but that had to do because there was an additional count on restrictions on OEMs. Okay, so the Apple complaint was assigned to, well, I should say one other thing. When the answers came back, both Apple and Google counterclaimed for damages. Remember that hot fix that was in? That stayed in effect. So there were purchases being made outside of the Apple system and the Google system and that was in violation of the developer agreement. Okay, so there was a breach of contract claim and damages. Okay, now what you're going to find interesting in all this is that when Apple filed its counterclaim, it did not seek a jury trial. When Google filed its counterclaim, it did. Okay, so Apple goes before Judge Yvonne Gonzalez-Rogers in the Northern District of Illinois, a very experienced antitrust judge. And she had a trial in May of 2021. It lasted 3 weeks. She took 3 months later to release her opinion. Her opinion is the one that's 195 pages in Westlaw. It's 666 footnotes. It is an incredibly detailed opinion. And among other things, what she did was she rejected the market definitions, which, as you can imagine, in this kind of a case, were critical to the outcome of the case. She rejected both Apple's and Epic's market definition and created her own market definition. Okay, and it was a clean sweep for Apple. On all of the antitrust counts, she decided in Apple's favor. Now, there was a California unfair competition count that she did decide in Epic's favor. Okay, but I'm going to focus just on the antitrust count. So clean sweep for Apple. Okay, now you move over to what was going on in the Epic Google case. That was assigned to Judge James Donato, another very experienced antitrust judge. A couple of MDLs under his belt. And before Judge Donato was on the bench, he had also been an antitrust litigator on the West Coast for a couple of decades. So he got the case, but in that case, it was MDL, so where a number of other cases were joined to it. All the other cases were also damages cases. All of those cases wanted jury trials. But before the trial actually took place, all of those other cases were settled. Okay, so all the other damages cases were now gone. We've only got Apple and Epic left in the case. And both Apple and Epic sort of stipulated that there was no doubt, there was no question that there was a violation of the developer agreement. So the only question was whether or not the restrictions that were violated were enforceable or whether or not they were void, because they violated the antitrust laws. So there was nothing for the jury to decide on the contract claim. Google wanted the contract, now that it was just a pure antitrust case and there was nothing but injunctive relief claims on both of the Epic suits, Google sort of, I'd say somewhat at the last minute, said, we really don't want a jury trial. And Judge Donato said, you asked for a jury trial, we're on the eve of a jury trial, you're getting a jury trial. So it went to the jury. Okay, it was a 4-week trial before the jury. Okay, it was 3 weeks before Judge Rogers in the Apple case. Remember, Judge Rogers took 3 months to write an opinion that was 195 pages long. I keep coming back to 195 pages because I can't believe how big it is. Okay, the jury deliberations took 3 hours. Okay, and it was a clean sweep for Google on the antitrust claims. Excuse me, it's a clean sweep. Yeah, thank you for that. Yeah, very, very important. It was a clean sweep for Epic. So in the Apple case, Apple won on all the antitrust claims. And in the Google case, which, as I said, was based on essentially the same facts, the same theories of anti-competitive harm, and the same counts, it just went in the polar opposite direction. Okay, and I mean, I think this is a pretty fascinating episode. You don't really get too many natural experiments where you basically got the same case going up, okay, before two really experienced judges. One's a jury trial and one's a bench trial, and they come up with diametrically opposed outcomes. But you did here. So, the bottom line for me in this is that when I think about, trying cases, I think about it mostly, and I've never done a jury trial, in the context of what you need to do is you need to win the hearts and the mind of the judge, that is the trier of fact. You want the heart is you want the trier of fact to believe that the outcome that you're seeking is the right outcome. Right? And then the mind part is, because it's a bench trial, the judge is going to have to write an opinion and justify, what outcome, she chooses, right? So there's going to be some weighing between how much you have to do to get to the heart and how much you have to do to the mind. Now, if you're in a jury trial, the jury doesn't have to explain what it did. Okay, so I've always thought that, again, stressing I've never done a jury trial, I've always thought that the way you win jury trials is you go for the heart, right? The mind doesn't matter that much. So basically what you're trying to do is you're trying to convince the jury that the defendant in the case is basically an evil player, okay? And they're doing something wrong, like charging this really, super competitively high 30%, commission. And the jury just figures out, well, what do I have to do in order to basically give some relief to the plaintiff? And I think that's what happened here. I think this is pretty embarrassing for the Ninth Circuit because now they've got two district courts that have gone in diametrically opposed, directions. I don't know how long it's going to last. There is a motion for a JMOL before Judge Donato, and among other things, I mean, it's a pretty well done motion. One of the things that's really fascinating about it is that the market definition, and as you can imagine in the jury case, was just the market definition that Epic had advanced, which was an Android market, basically an Android only. It excluded the iOS app systems. Okay? But that's not what Judge Rogers found, and that was fully litigated in the Apple case that had taken place 2 years before. So one of the first arguments that Google is making is that there should have been, offensive claim preclusion, offensive collateral estoppel on this. And if Judge Donato decides that he wants to reconcile these opinions, that's probably a good way for him to go. So I've got two questions to leave you with, okay? Well, I don't know the answers to these questions, but you can ponder them yourself. One is, why in the world did Google ask for a jury trial, okay? And the other question was, why in the world didn't Epic include a damages claim and ask for a jury trial? And so I'll leave it at that.
Thank you, Dale. I'm going to switch to Ling here, switch gears a bit, but staying within litigation and tech to a degree. And this is about pricing algorithms. And this is an increasing part and concern of the digital market, but it also can promote efficiencies. I think maybe the past 5 to 10 years it's been puttering along. It's largely conceptual. There's been some agency concerns. I think a few cases that were at least complaints. The Tompkins case that the DOJ brought, and that was about like posters on Amazon of all things. Gibson versus MGM Resorts. But yet there is now a new case, RealPage, that the DC Attorney General has announced a lawsuit, and RealPage is used by landlords, very large ones, to set rents. And so there's a question as to whether or not this is setting it in a way that's harming the renters. So Ling, could you give some background on this complaint, this lawsuit, give some commentary on this technology, and perhaps some ways that we can distinguish legitimate from illegitimate ways to use pricing algorithms?
Sure, my pleasure. So RealPage is a technology company that provides property management software, including revenue management software that includes algorithms trained on data, which RealPage obtains from its landlord clients. On November 1st, 2023, the DC Attorney General filed suit against RealPage, claiming that RealPage and 14 large DC landlords unlawfully colluded to raise rents by collectively adopting rent set by RealPage technology and unlawfully agreeing to exchange competitively sensitive data. There's a single count in this complaint brought under the DC Antitrust Act. So I thought that this would be interesting to talk about today for 5 reasons. First of all, as John mentioned, it concerns algorithmic collusion, but algorithmic collusion through a channel that we often don't see discussed academically, which is through the training data. Second, it's embedded in a larger set of cases and public policy that concerns the role of pricing algorithms, particularly with respect to data collected from multiple market participants. It also, third, serves as an example of the importance of thinking about cases outside of cases involving the Magnificent Seven when we think about tech and antitrust. Fourth, it raises how tech is applied in more traditional industries, particularly with respect to how we think about tech furnished by third-party vendors. fifth, I think this hits close to home for many of us. It's about DC apartments, after all. But I'd also say it hits close to home for me because much of my work is about financial services. And in financial services, we see pricing and underwriting models all the time. And we can get fancy about it. We can call them algorithms. But this is kind of a norm that has existed for decades. So when I think about the work on algorithmic collusion, I think about analysis related to algorithms that either make use of a firm's own data or publicly available data about its competitors, often with a focus on tacit collusion through independent algorithms such as monitoring algorithms. The premise of this case is obviously different, as it focuses on the data on which a pricing algorithm is trained, and the alleged collusion is through the provision of training data to a third party. So taking a step back and thinking about where else we've seen this, third parties collecting and pooling client data and monetizing it through products that are marketed as providing market intelligence is not a new phenomenon. For example, payment processors provide data analytic services that include benchmarking of clients against their competitors, and a mortgage servicing platform provider sells de-identified client loan data to basically anyone who's willing to subscribe. Further, third-party pricing tools have been extant for years. For example, the government-sponsored enterprise, Fannie Mae, provides a publicly available underwriting tool called Desktop Underwriter. So the important thing about the DC Attorney General's case about RealPage is that it raises questions about whether and how third-party pricing algorithms can exist. The case has the potential to limit third-party vendors' use of client data to train pricing algorithms. Vendors supplying pricing algorithms may be required to limit the training data to the data obtained from a particular client and publicly available data. When we think about what that actually means for the algorithms, this could affect their predictive power as well as potentially lead to bias. Basically, the inputs can possibly lead to bias if the inputs are biased. When we think about what this means for smaller firms who are seeking to make use of pricing algorithms, this may mean that they don't have access to as reliable training data. If we think about this from the third-party vendor's perspective, providing pricing algorithm services may become less profitable or more costly, as individualized algorithms would have to be produced for individual clients. So let's think about this in a broader context, and the DC AG's case is not the only case against RealPage of this nature. There's also a class action in the Middle District of Tennessee in RealPage rental software antitrust litigation with similar allegations, but brought under Section 1 of the Sherman Act and various state antitrust laws. In RealPage, the DOJ has submitted a statement of interest asserting that the per se rule prohibiting price fixing applies to price fixing using algorithms. Furthermore, the issue of training data has also received public policy attention in a couple of Senate bills brought to the floor by Democratic senators, including the Preventing Algorithmic Collusion Act and the Preventing the Algorithmic Facilitation of Rental Housing Cartels Act. In particular, the Preventing Algorithmic Collusion Act would change the law to presume a price-fixing agreement when direct competitors share competitively sensitive information through a pricing algorithm to raise prices, and ban companies from using competitively sensitive information from their direct competitors to inform or train a pricing algorithm. So all of this is to say that the use of third-party pricing algorithms and the way the associated training data is gathered and used is under scrutiny, and tracking the RealPage cases could be a helpful way to see the related policy unfold.
Thank you, Ling. I think one of the things that fascinates me about pricing algorithms, particularly in the context of litigation, is how it will be tried. I mean, it naturally fits under a per se illegal rule, but if we really unpeel what per se means, you have to first determine whether the conduct falls under that actual umbrella. That doesn't seem so straightforward to me when people meet in a room and smoke cigars and agree on price. That's straightforward. Did they have that agreement? Did they meet? All those things. But here, we have to unpack the algorithm a bit in terms of what it's doing. And I'm not saying this is now rule of reason, but I don't know if anyone has any thoughts on whether, if this came to litigation and both sides are fully sort of staffed with economists on both ends, if this is just going to be a straightforward per se, or is this going to create a little navigation between per se and rule of reason? I don't know. I'm just.
Yeah, if I could jump in.
Yeah.
I think a lot's going to depend on, first in the first instance, what was alleged to be the agreement, and secondly, what was proved at trial to be the agreement. In the MDL, the allegation actually is that the parties all agreed to use RealPage and its pricing algorithm, but RealPage in particular, as its, if you will, joint selling agent, and strike the selling and put in pricing instead, it's joint pricing agent. And if that's, and that is the basis on which the motions to dismiss in that case were denied. I mean, this is a pretty straightforward allegation, independently of how in the world the joint pricing agent came up with the price. Here it used an algorithm. The fact that the competitors agreed, allegedly, to use a common joint pricing agent was enough, I think, to give rise to a fairly traditional per se violation. Now, if you take that away, and all you have is basically the information, that's non-public information, proprietary information that's being fed into the algorithm, then I'm not quite sure, what the nature of the agreement is, and I'm a little more, sure that unless you can infer a horizontal price fixing agreement out of that, like Container, Corp did, that you're going to have a rule of reason case. And I have this hypothetical to give you. Let's say, here's the way, just real quick, here's the way I understand RealPage works, and this is from like 10 minutes on its website. So what it does is it collects a bunch of information on both prices and I think vacancy times on apartments. And it basically tries to generate a price elasticity. Forget about whether it does a good job or a bad job of that. And it claims it's able to even do it down on an individual apartment level. Okay, and if you look at their videos and stuff, they really stress this price elasticity algorithm that they've got. Now, assuming that that's what they do, you can take price elasticity, you flip it into marginal revenue, and then from your Economics 101 course that if you equate marginal revenue to marginal cost, then you can get a profit maximizing price out of that. So what happens if instead of giving a price, they just give you the elasticities? The landlords input in their own programs what their marginal cost is. They equate the two, generate a profit maximizing price. Is that a problem? I find it hard to believe that could be a problem. So I'm just not sure where this is all going. As I said, in the Middle District of Tennessee, I think that at least the allegation is that they agreed to use a joint pricing agent. In D.C., I guess it's not that they didn't allege that, did they?
I don't believe they did.
Yeah, so that'll be interesting.
So if I can
Go
jump
ahead,
in.
Michael.
So suppose you're collecting information from what is plainly a competitive market, and what the algorithm is doing is it is computing the market clearing price. How could that possibly be any competitive? Now, in the alternative, it's producing a price. So that would seem to be a possibility. I mean, after all, that's basically what Uber does and what Lyft does. In the alternative, it's producing something other than the market clearing price, in which case there's going to be a restriction of output, and there are going to be some apartments that don't go rented. And then the question is, are the owners of those apartments in this clearly competitive industry, if it is clearly competitive, are they going to stick with that price and have the open apartments? So, I think it's got to be rule of reason.
Well, I think just on that real quickly, this is a matter of law. If you have a bunch of competitors, let's take the following, everybody stipulates to this, that you have a bunch of competitors and what they do is they agree that they're going to charge the competitive price. But they have a horizontal agreement that says they're going to charge the competitive price. Okay? And however you want to interpret competitive price, it's the way that the antitrust laws interpret it. Under Saccone vacuum, that is a per se illegal violation. Okay? Now, there are no damages from it. There are lots of per se cases in which there are no damages. So this would be one where a private plaintiff couldn't obtain any damages, but the government could put people in jail for it.
Gosh, great thoughts. I'm going to switch to Kristen. In the first panel, for those who were here, there was some discussion. It was like Dennis Carlton and Aviv Nevo. It's like Godzilla and King Kong. It's just watching two titans just battle it out. So I was enjoying it, and I gained a lot from their insights. So one thing that did come up was potential nascent competition. And so it's a topic I think that's worth discussing. And so I want to get your insights on this, Kristen, given your experience. And we can use Meta within or Facebook, Instagram, WhatsApp as an example. But how should the FTC's case, let's say, on these specific companies, WhatsApp, Instagram, Facebook, be assessed? What's the right counterfactual? And I think that, to me, is a real open question of how the agencies are approaching the counterfactual. And broadly, what standards should the courts use? Dennis alluded to a perceived potential competition. Kristen, maybe you could unpack that relative to actual potential competition and whether we need a sort of a de novo nascent competition standard. Maybe a lot in there, but why don't you take us through that, Kristen?
Thank you, John. I'm a little bit nervous in the Godzilla versus King Kong, who I am in that movie, but I will take a stab at it. There's been a lot of ink spilled about the agency's new focus on potential competition and nascent competition. I guess I would just start by level setting that this is not exactly new, right? The agencies have been challenging transactions involving potential competitors, nascent competitors for decades. Those cases don't always get styled as such because, in truth, the analysis isn't, or at least in my view, shouldn't be all that different from regular Section 7 analysis, which is always forward-looking. What will the market look like with and without this transaction? Is one substantially less competitive than the other? The likelihood of entry or expansion or even contraction of the merging parties is always going to be relevant to that inquiry. So I think from my perspective, I'm generally against potential competition exceptionalism, if that's a term. And that's why I find the conversation around Meta within a bit puzzling / beside the point, right? The FTC lost on the facts there, but declared at least partial victory because the court endorsed the viability of a potential competition doctrine. But I think if you read what the court said there, it doesn't strike me as particularly novel or particularly helpful if I'm the agency, right? As I said, the agencies have been successfully and sometimes unsuccessfully, but challenging transactions involving potential competitors for a long time. In my view, Section 7 already gives them everything they need to do that, provided the facts support the claim. The separate doctrines of actual potential competition and perceived potential competition, those have generally confused and stymied the courts. If anything, they appear to impose a higher burden on the agencies as far as I can tell. That's why there's only one or two of them in the wild, right? Where a court has actually blocked a transaction based on these special doctrines. So if I'm the agencies, I don't want to rely on actual potential, perceived potential, nascent potential competition doctrines, right? I want to say Section 7 has an incipiency standard. Based on the facts here, it's met. No special labels, no tricks, no gimmicks. This is just straight up Clayton Act analysis. So Facebook, you mentioned Facebook, Instagram. I think that presents sort of an interesting wrinkle on how you do this analysis, right? Because it requires us, given the timing of the lawsuit, to go back in time to do the forward-looking analysis. But I don't think the analysis fundamentally changes because under Section 7, we still have to evaluate the legality of the transaction based on the world at the time it was consummated. The merger can't have been lawful in 2012 and become unlawful today. That would essentially create a no-fault liability standard for merging parties whose transactions, potentially through unforeseen or unforeseeable events, changes in legality over time. That's not how this works. So to put it in terms of Facebook and Instagram, the question's not whether the Facebook of today could buy the Instagram of today. It's whether Facebook buying Instagram in 2012 was likely to reduce competition relative to the world where Facebook doesn't buy Instagram in 2012. And the way I like to think about this is through the lens of Back to the Future, right? So when Michael J. Fox's character goes back in time and he starts to interact with his parents, their high school students, and he's interacting with them at the time at which they come together. And as he does that, and he changes the events, the picture of his family that he has in his pocket, he and his siblings start to fade from the photograph, right? Because as we know from Back to the Future and every other time travel movie, you change events in the past, you change the future. So we know what the world looks like when Facebook buys Instagram. That's the timeline we're living in. What happens in the alternate timeline where Instagram is not purchased by Facebook? Does it develop into the sort of robust social media competitor to Facebook that one might imagine? That's the part that's not obvious to me and that I think makes the case, the FTC's case, so difficult, right? In 2012, Instagram has about a dozen employees. The app allows you to put photos out into the world, but it doesn't have any of the social networking capabilities that we know today, right? There's no direct messaging that's not connecting people in the same way. And importantly, it doesn't have any monetization or idea of how to monetize the product. So all of that comes from the investment by Facebook. Capital investment, of course, but also the know-how and the experience that Facebook had at that point. So then you get development of stories and direct messaging and all that sort of stuff, and of course, monetization. So could Instagram have gotten there without the Facebook acquisition? I think that's the question, that's the but-for world, I think, that's relevant to that analysis. If so, then the transaction, yes, maybe we didn't figure it out until many, many years later, was unlawful in 2012. But if not, if instead it developed all of that because of Facebook's investment, then I think not only was the merger not a problem, but it provided a ton of benefits, right? Because Instagram users and advertisers that use that platform today have reaped a lot of consumer benefits. So that's my thoughts about that.
Okay. Thank you, Kristen. Let me ask a follow-up, and if you want to punt on it and someone wants to pick it up. What are the prospects for the DuPont rule, which is no latches against the federal agencies challenging mergers likely to survive if there's an appeal in the Facebook case?
Well, I think the latches question is a really interesting one, and the only thing I'll say, and then I'm going to kick it to Dale because I know he has more fully formed thoughts on this. But whether or not the DuPont decision survives, there's a broader question about latches against the federal government that goes well beyond the merger analysis. And so I expect if that is challenged in the Supreme Court, there's going to be a fair bit of fight from the Justice Department to preserve that doctrine and its broad application, right? Because obviously that would have lots of knock-on consequences outside the antitrust context. But Dale, you have some.
Yeah, I think I have a slightly different view. First of all, I think that what will happen is Judge Boasberg did in the motion to dismiss agree that latches doesn't apply against the federal government in this case. I think that will go up on appeal. To the D.C. Circuit. I suspect that the D.C. Circuit will affirm that decision, but just given the posture of the case, cert will undoubtedly be petitioned for, and I think the Supreme Court will take it. And I also think that the Supreme Court will, I don't know whether it's going to be 5-4 or 6-3, but will basically abrogate the DuPont decision. A couple of things have happened. The biggest thing that's happened since DuPont has been the Hart-Scott-Rodino Act. So now there is, a mechanism for a full vetting of a deal before it happens. And in fact, there was a second request investigation of, I think, both of those transactions. And the FTC at the time, closed the investigations without taking enforcement action. I think even though there's not supposed to be really too much of a reliance interest that's packed into the, latches doctrine, I think it's hard to avoid, courts thinking, particularly the Supreme Court thinking, about how Facebook's investment in Instagram and WhatsApp would have changed if they thought, if Facebook thought there was a realistic opportunity. Years later, some new administration comes in with a much more aggressive view of what antitrust is all about and challenges the deal. And my guess is I'm not quite sure how they're going to articulate what the change is going to be, but as I said, I think they're going to abrogate DuPont.
And if I could just put in a plug, because there has been litigation on the application of that to the state's parallel claim, right? And that became an issue in the DC Circuit. And there's an amicus brief by Shauna Wallace at Indiana that walks through HSR and its implications. And obviously there's a lot more flexibility there because the states are differently positioned than the federal government in this regard. But I do think that's a really interesting analysis for someone to grapple with the impact of HSR on these questions.
Thank you, Kristen. Thank you, Dale. And I guess we can ask Justice Gorsuch later on. I'm sure he won't mind
He'll
me
be happy to share his
interrupting his conversation with Judge Ginsburg for my laches question. I've always found it interesting. My last thought on potential nascent is what those who perceive the Instagram merger as anti-competitive, particularly a really bad anti-competitive acquisition, what would the acquisition have? What would the world be where it's not anti-competitive? Is there even a scenario after they acquired Instagram where it would not be considered anti-competitive? I don't think I've ever sort of heard a good answer to that, and so it concerns me as to whether or not there's any defense to that acquisition at all. So with that,
Can I just add one quick
please
thing,
do.
just now that you brought that up? One of the distinctions that we haven't drawn, at least not that clearly, but I think is a real distinction that everybody should keep in mind, is the difference between a potential competition theory, particularly an actual potential competition theory, and a nascent competition theory. Okay, I mean, actual potential competition, I mean, that doctrine's been around since the 70s. It's never been blessed by the Supreme Court, but basically every modern court has been willing to entertain it. By the way, I don't think any modern court has actually decided that, found liability on an actual potential competition theory. I mean, there just haven't been many of them, and they mostly get wiped out for, any number of reasons. But the key to potential competition, the traditional doctrine, is that the target company, 2 points to it, the target company, the potential entrant, has to have basically, there needs to be a reasonable probability of fairly imminent entry. That's number one. And the second one, which hardly ever tried because you don't get that far, because it always loses on the first one, is that the entry has to be, it has to have a pro-competitive effect in the marketplace, right? So that means that not only there's entry, but the firm's got to survive, it's got to grow, it's actually got to have some anti-competitive, some pro-competitive effect. That's actual potential. Okay, nascent, the way that the agencies, starting in the Trump administration with things like Visa Plaid, their view was quite different. And that is, if you have a dominant firm that's acquiring, say, a new technology, and the new technology's got, right now, no intention of competing with the dominant firm and undermining its position. But sometime in the future, according to the agencies, it could have that potential, either on its own or because it's licensed the technology to a third party or because it's sold itself to some third party. But if you could conceive of it having a pro-competitive effect and undermining the dominant position of the acquirer, that would satisfy in the government's mind, the way I interpret their nascent competition theory, that would satisfy the elements of the nascent competition theory and justify bringing a complaint. That case has not been brought yet. They tried, they included the count in Microsoft Activision, but they dropped the count during pretrial, so it was not tried.
Thank you, Dale. No, I think that's an important distinction you just brought out. Michael, I want to turn to you and talk about vertical integration and self-preferencing. Obviously, in different contexts, that's come up in litigation for these digital markets, although it's not unique to digital markets. These practices are clearly under scrutiny, where there's sort of this idea of a conflict of interest as both being a platform being both a host and in some way a downstream competitor. So can you walk us through the theory, the thoughts, and in your view, how we distinguish pro-competitive from anti-competitive practices involving alleged self-preferencing?
Okay, thanks. Thanks for inviting me. Boston University requires that whenever I speak publicly, if I have to disclose any consulting relationships that might seem relevant. So I've done a lot of work for Google over the years on alleged algorithmic bias, which I think is relevant to your question. When you talk about vertical integration and self-preferencing and the appropriate antitrust treatment of it, you have to distinguish first between vertical integration and vertical mergers. Because vertical integration is entry, And entry has to be presumptively pro-competitive. And that's true even if the vertical integration is going to entail a great deal of self-preferencing. Indeed, the incentive for a company to vertically integrate is greatest when performance at the adjacent stage is less than competitive. And it's precisely when performance at the adjacent stage is less than competitive that there's going to be this strong self-preferencing incentive. Now, when you get to mergers, things are more subtle because that's not entry. So the first thing is, it would really be helpful to have a clear statement from the agencies and the courts with respect to the issue of what constitutes an anti-competitive vertical merger, because there are a couple conceptual standards for what that might mean. So one possibility is consumer harm. Indeed, if you look at the Justice Department's case in Time Warner AT&T, they tried to demonstrate consumer harm, presumably because they believe that's the standard, right? Another standard is raising rivals' costs, right? And those are different things because it's very possible to have a vertical merger in which the cost of an input to a rival goes up, but there's still net consumer benefit. Until recently, one wouldn't have thought that harm to competitors was a third conceptual standard, but given the recent merger guidelines, I think we need to entertain that possibility. And given the discussion earlier, about Europe and the need for contestability, in Europe, maybe that's a standard. And you can certainly have a vertical merger that benefits consumers, results in a lower price of the input to competitors, and yet causes the profits of the competitors to go down, right? So we need to be clear on what it is. And whatever it is, look, if the standard is consumer welfare, then the agencies need to say, okay, the standard's consumer welfare, and that's true even if the price of the input is going to go up. Or if they say raising rivals' cost is sufficient, they need to acknowledge that we're going to block some mergers even though it's going to result in net consumer benefit. Now, suppose consumer harm is the standard. Then there has to be a very strong presumption that vertical mergers are pro-competitive. It's possible to come up with an economic model in which vertical mergers result in consumer harm, but the models that do that are very fragile, and they might pass muster in the seminar room, but when you get into the courtroom, where you're subject to cross-examination and an expert who has a different model, it's going to be very easy to demonstrate that the demonstration of consumer harm is sensitive to some unsupported assumptions. Why does it happen? Why is it that as a matter of economics, there's got to be a strong presumption of consumer benefit? Well, it's because of the elimination of double marginalization, right? And Aviv, was saying earlier today that, that's part of the defense. That should not be part of the defense. That should be, that's a first order price incentive effect that needs to be taken into account. Okay, now, suppose that the standard is raising rivals' costs, which is a weaker standard. Surprisingly, you might think that if there's say you have a monopolist selling to competing downstream firms, and the monopolist merges with just one of the downstream firms, you might think as a matter of economics, like it's completely obvious that the monopolist is going to raise the price to the competing downstream firms. And as a matter of economics, that just is not right. It's very possible, even in that assumption where where it's literally a monopolist doing the vertical merger, and the monopolist therefore has the ability to raise the price. If you talk about the ability and the incentive in that structural setting can be to lower the price. Okay, and that's because the elimination of double marginalization creates an inherently more competitive market in which, in which the monopolist is really forced to lower the price to its other downstream customers. The agencies will say it's better, better to have them, and this is true a lot in the tech sector, mergers. It would be better for one of these big companies to invest directly rather than to merge. And I mean, I think it ignores the reality of these tech marketplaces, that a lot of the times when the big tech platforms buy something that they can integrate into their platforms, they're buying this small development team that came up with a good idea that doesn't have a prayer of commercializing it on their own. And it also presumes that these big tech platforms have a perfectly elastic supply of engineering talent to develop whatever it is they want, and that's simply not true. Okay, and then finally, talking about potential competition. The one case where I think there really is a very compelling potential competition case to be made is when you have successive dominance. Because when you have successive dominance, the company that has the greatest incentive to restrain the dominance of the firm at the adjacent stage is the dominant firm at the other stage. So, go back to the late 90s and suppose Microsoft and Intel had wanted to merge, right? So from a static pricing standpoint, you say elimination of double marginalization, that's great. But from a potential competition standpoint, who had the greatest incentive to see the operating system market become more competitive? It was Intel, and vice versa. And why was Microsoft promoting AMD, right? Because they would benefit from the from the reduction in the price of the microprocessors. Or if you want a somewhat more recent example, think about Live Nation Ticketmaster. So, if the agencies are going to challenge vertical mergers, they really need to have a clear statement as to what determines the vertical mergers that they're going to bring. And I thought I was the only person who thought this, but in the preparation, Dale told me he agreed with me. If you go back to the 80...
No one's ever said that to me.
If you go back to the 82 and 84 merger guidelines, which almost everyone said needed to be updated for vertical mergers, they state this potential competition theory as a basis for blocking vertical mergers, and that's what the agencies should stick with.
Thank you, Michael. And you brought up some really good points, especially I just wanted to highlight two because I think it's worth emphasizing, one of which is when there's an assertion that larger firms should just organically grow, it just ignores fundamentally the economic principle of comparative advantage, and that's really a stunning sort of assumption to wash away that idea. And the second is EDM is a price effect, and it's often sort of characterized as some type of efficiency. I'm not saying Aviv says this or anything like that, but I have read it viewed as sort of this efficiency defense that you can maybe make, but it really is a price effect, just like Guppy is a price effect for horizontal mergers, and I think that's an important distinction. So actually, let me...
Can I?
Yeah, go ahead, Dale.
Say
Yes,
my name was
anytime.
taken in
Yes.
vain, or not so much in vain.
I was complimenting
I viewed it
you.
as complimentary.
So I agree with a lot of what Michael said, but I would like to just comment on one thing, and that is, and it has to do with the elimination of double marginalization and the proof of a prima facie anti-competitive effect in a vertical merger. I don't see that there's any problem of basically using something like a raising rivals cost model just on the raising rivals cost independently of EDM to prove in stage one of Baker Hughes, for example, that there's an anti-competitive tendency of the deal. that would make the deal violate Section 7 unless there was some offsetting, and I'm going to call it a pro-competitive benefit, but that's not quite the way I think about it. I think of this like vectors. There's a vector of price increasing pressure, and there's a vector going downwards of the efficiency, here EDM. So I don't think there's any problem. I think the big problem in the AT&T Time Warner case, and Alex and I have talked about this before, is that the Justice Department decided to try the case and put both EDM and raising rivals costs into the prima facie case. They should have just done raising rivals costs and turned it over to the merging companies and said, look, if you think there's an EDM theory here that provides an offsetting, price effect, then prove it. And that's my second point. I've never done this, but my intuition is that if you are the defense and you have the burden, certainly the burden of persuasion, but if you have just even the burden of going forward, you could have a real difficult time proving that EDM exists in your transaction. I mean, my guess is if you put the Time Warner executives on the stand and ask them about their prior vertical deals of which they had, excuse me, I said Prime, well, let's say AT&T, the AT&T executives on the stand and ask them about their prior experience in vertical mergers of implementing elimination of double marginalization. I think that the prosecution in that could just take them apart. I think it'd be extremely difficult to show in most of those cases, and this is an intuition, I don't have any empirical evidence on this. My intuition is it'd be extremely difficult to show that there was an EDM effect in their past vertical mergers. The theory is wonderful, the math is really quite elegant, but I think in practice there are a lot of problems, not the least of which being most of these things within the company are profit and loss centers, and the executives are being compensated on things like their year-over-year profit gains. And they don't want to, you ask in the integrated AT&T Time Warner firm, you ask the guy who's running the Time Warner content business whether or not they're willing to sell at marginal cost to the AT&T DirecTV business, and he's going to say, there's no way in the world I'm going to do that. Now, the higher echelon gods within the company could force them to do it, but I think it's going to be really hard to prove that would happen.
Thank you, Dale. I just want to do a preview of when we're going to stop. We're going to stop at 3:25 hard stop, and I'll have an announcement at that time. We can't really go over. So with that, just giving warning to the panelists as well. I don't like to be the guy cutting people off, but I will, or people get mad. So Kristen, I want to stay with vertical mergers and get your view on how and with what success do you believe that the Biden Antitrust Administration and the agencies are trying to expand the reach of antitrust law into vertical mergers, Microsoft Activision. We heard earlier about Illumina Grail, and just get your thoughts on that.
Thanks. Well, we've already heard a lot of good stuff about vertical mergers from Michael and endorsed by Dale. I don't know that I can add much to that. So maybe I'll skip, and given the press of time, to one aspect of sort of this expansion or increased focus, and that is what remedies have to do with vertical merger enforcement, and to what extent the agencies and courts believe that the potential harms from vertical mergers can be remedied with something short of blocking the transaction. So when foreclosure is the concern, smart companies try to get ahead of that issue, right, by entering contractual commitments with would-be complainants to ensure supply of products that might otherwise be foreclosed or access points that might otherwise be, what's the word in the guidelines, clog the access points. The U.S. agencies generally take a very dim view of this, but I think the experience, and you see this both in Illumina Grail and in Microsoft Activision to varying degrees, courts are generally not willing to ignore them, right? So in Illumina Grail, the parties entered into an open offer supply agreement to give Grail's would-be rivals the same access to the platform at the same prices. The ALJ found that agreement effectively constrained Illumina's ability to harm Grail's rivals and rebutted any claim of alleged harm. and relied on both the sort of enforcement mechanisms in the agreement, right, the contractual monitoring and the binding arbitration and such, but also the reputational harm that Illumina would suffer if it breached that to support his conclusion that this was sufficient to eliminate the ability/incentive. But the commission disagreed and overruled the ALJ on that point. Their rejection seems to me a bit more ideological than evidence-based, right? Essentially, that contractual measures can't substitute for the incentives in a competitive marketplace. Microsoft Activision, similarly, the parties entered into contractual commitments, supply commitments. The FTC took a dim view of them. The CMA and the EC had, of course, their own back and forth about the impact of them, which we don't have enough time for on this panel or perhaps any other panel to cover. But the district court in that case was not only willing to take them into account, but found that because they cemented access to the games, to the 5 cloud gaming providers, the agreements and thus the merger actually enhanced competition in the cloud streaming market. So I think this continues to be an area where the agencies are running into a bit of friction with the courts. This isn't a Biden administration special. The same issue arose in AT&T Time Warner, where the Trump administration argued vigorously the contractual commitments there and the baseball-style arbitration shouldn't be considered at all or couldn't address the competitive harm. And of course, Judge Leon didn't see it that way. So I think this is going to continue to be an issue. That's not to say that the antitrust agency's policy isn't having a real effect, because of course, transactions are abandoned all the time in the face of agency scrutiny and agency opposition to a proposed remedy. But I'm not sure that if tested, the law would actually support that. So maybe I'll leave it there and so you can get to the rest of the questions.
Thank you, Kristen. I want to go to Ling. I feel like economics and economists have been beaten up a little bit lately. We've been thrown to an appendices, but rescued. So I guess we should be thankful that we're not still there. But given your experience as an expert in these types of cases involving digital markets and other markets and role as an economist, what type of evidence have you given your experience, found persuasive as it relates to these types of markets, including your interface perhaps with data teams for some of these larger companies and what they could provide to that sort of argument?
So I would say that empirical evidence is incredibly powerful, and having a combination of strong theoretical arguments that are backed up by empirical arguments can be really powerful. One challenge in particularly the tech space is that there is just a lot of data, but not all of that data is necessarily germane to the economic arguments. So I really think that when I'm thinking about fielding teams for these cases, it's really important to have a team that not only has great data skills, but also really understands the economics. I think that data requests are particularly important in this context because you can basically ask for the moon now, but that doesn't help you when you have petabytes of data, you're trying to get an expert report out, and you're trying to get turnover over to the other side. So I think that really going in with a plan, thinking about what you're going to measure and how to measure it, can be really tactically important. In terms of interfacing with economists and data scientists at the client, something to keep in mind is that while there's a lot of data in tech, there's variation in the level of sophistication with data at the client. I know that in my experience, there haven't always been data people at the client. In fact, when you think about a lot of tech firms, they're actually working off of other platforms and using third-party data vendors. For example, I've done some e-commerce work where the clients have actually been using a third-party platform of the flavor of Shopify or Lightspeed. And because of these third-party relationships, sometimes you have to build in time and resources to negotiate things. And in certain cases, I know I've been on one, come up with a plan B if you can't get the third-party data vendor to agree. So in terms of the economic sophistication of clients, yes, there are plenty of tech companies that employ PhD economists, but their roles can be very varied. We've seen some very experienced PhD economists in terms of their antitrust chops. They've either come from economic consulting or they've come from government. But there are also roles for PhD economists that are purely pricing team. And so you're not necessarily going to get the same thought process out of them as you would from somebody with antitrust experience. I'd also say that it's fantastic to talk to data scientists most of the time because it's just nice to speak to someone who, quote unquote, speaks data. But when thinking about what their mandate is, they're basically trying to run the day-to-day. And if anything, they're looking to work on prediction. And so the way that they think about the data isn't necessarily the way that I would think about it, because I'm basically trying to estimate things in a backwards-looking way. So anyhow, in terms of what to take away from this, it's that working on these tech cases and executing not only requires really thoughtful economics, but a lot of it is honestly in the weeds, and it is a lot of planning and execution.
Thank you, Ling. Dale, I want to come back to something you highlighted in your initial remarks regarding the two different cases you contrasted, and the relevant markets were very different in those cases. So what's your view on relevant markets? And I suppose it's case by case, we all realize, but do you have any sort of broad overviews on whether the sort of the aftermarkets doctrine, which Epic versus Apple, Epic tried to assert that in that case, it didn't work, whether that has any life left going forward?
Yeah, so two quick things on this. So one is, I think that for all the criticisms market definition has, I think that, particularly when you're litigating in court, it's just absolutely critical, right? I mean, if you can't identify where the anti-competitive effect is located, assuming you're not in the hardcore price fixing case, right? I mean, the judge is going to be very reluctant to find that there's a problem. And by the same token, I know earlier, the first panel, there were talks about, what's the significance of the HHIs and so on. I think the economics on the HHIs is, the empirical evidence showing that HHI thresholds at any particular level is where the trigger point should be, that stuff hardly exists. But there's no question that judges expect to see it. So if you've got high market shares, high HHIs, they're going to be very well inclined to, fine for the government, say, on a merger case. So now I think if you're at the agencies, I think just the opposite is true. I don't think I mean, in my last 20 years of practicing before the agencies, I don't think we ever talked about market definition. What we basically talked about was how many realistic suppliers would the customers in the industry have if we, after this deal was done. And if the number was high enough, and the number is usually about, depending on the transaction, it could be 3 or 4 or 5, that was pretty much the end of the case. I mean, it's a great predictor of, at least it was, of agency investigation outcomes, is just looking at the number of players that are going to be left there after it's over. Now, on the specific question about aftermarkets, I mean, what we saw in a big difference between the Epic Games cases between Apple and Google was Judge Rogers and Apple said that under Ninth Circuit precedent, there really couldn't be a single firm aftermarket. So she rejected, pretty much as a matter of law, okay, contrary to precedent, an iOS app distribution market and an iOS in-app payment systems market, and said that Apple and Google, both those systems had to be in the same market. Okay. Now, when you go over to the Google case, I mean, that was a pure Android market. And one of the questions that's being raised in the motion, the JMOL motion, is whether or not that's consistent with Ninth Circuit law. I mean, one of the all this stuff is basically grounded in the Kodak case, And one of the things in the Kodak case was there was, if you will, this is not the way the court put it, but there was sort of a bait and switch that went on in the Kodak case. You know, the buyers of the high-speed copiers thought at the time they were buying them that they could be using, you know, ISO, independent service organizations. And then after they bought these expensive copiers, Kodak changed its policy and they could no longer do it, okay? And that, to a lot of people, and to the Ninth Circuit in particular, seemed to be one of the keys to the cases. So if you had one of these, what I'll call bait and switch, or it's not really that, but you know, there was a change in policy, then you could have single firm aftermarkets. But if there was no change in policy, that is at the time that the purchase of the original product was made, here say an iPhone, you know, or an Android phone, that you knew that all the apps had to be, had to be distributed through the App Store, that there was a 30% commission being charged, I mean, all of that, then, you know, later in time, according to Judge Rogers, and now the motion for the JML is saying the same thing, as you would imagine, is saying that, well, you know, if that's the case, then you can't have a single firm aftermarket. So we'll see how that goes.
Thank you, Dale. Michael, why don't you bring us home in terms of the last formal question? We'll see if we have time for audience questions. And so from the perspective of economic evidence, what exactly is the burden of production on the plaintiffs to bring a sort of prove harm with platform-based types of markets, especially since Ohio versus American Express, there's been a belief that it really raised the burden on them. And in turn, if you wanted to comment on the pro-competitive effects and the burden on the defense.
Well, you know, the American Express decision, you know, what it said about two-sided markets and, you know, what constituted a relevant market was, I think, quite sensible. The rest of the decision, I think, made no sense. With respect to, you know, how are platform markets different? I mean, I guess the question I would ask is, you know, is the platform an essential facility? And if it's not an essential facility, then, you know, then in terms of vertical integration issues, I don't think it really changes things very much. You know, and then you get back to the issue of what constitutes an anti-competitive vertical merger. You know, is it consumer harm? Is it harm? Is it a raising rivals cost? And is it, you know, or is it harm to a competitor? You know, and on Dale's point that, you know, why don't you just bring a raising rivals cost effect? I mean, the problem is that the raising rivals cost effect interacts with the elimination of double marginalization. You can't view it as an independent effect as a matter of economics.
If you think about it, the vectors, you certainly can't, right?
No,
There's an
no,
upward pricing pressure going up, there's a downward pricing pressure going down. If you just think about it just in an economics 101 demand and the supply curve with marginal revenue curves, you could trace the whole thing out that way, right? I mean, and the way that the unilateral effects, which is related to all this, you know, equations go, you know, there's a cross partial that's in there that basically is the upward pricing pressure, and then the marginal cost reduction is the downward pricing pressure.
So at the risk of promoting my own work, I refer you to two recent papers by CRA colleague Martino Di Stefano and me that works out how the complicated interactions among these effects.
I'll take a look.
I will send it to you.
So we have time for probably one or two audience questions. And I know the students are generously have the mics, but is anyone have any questions for our panel, or did we cover it all? And there's no, oh no, we didn't cover it all. So there's one up front here.
Thank you. This is very interesting. What do you think Epic's aims were in their case against Apple and Google? Do they think that did they actually believe that they would get a definitive ruling? I mean, was it just a stunt?
No, I think they're, here's my guess, right? I mean, I don't know anything about what was really going on, you know, other than what's in the opinions and what's in the trade press. But But one of the things that was going on with both Apple and Google is that the 30% commission, which a lot of people complain about being so high, was really part of the in-app processing system, okay? And I think that the view, very mistaken view, was that if they could knock out the restriction that you had to use the in-app processing system and you could go outside the app, then you could either use your own payment systems or somebody else's payment systems where the commissions would be much, much lower. This was a pure play to get to basically get the commissions that Epic was paying down. Now, what Epic didn't understand, and I'm surprised that Apple didn't do something and Google didn't do something about this earlier, but now Apple has done something about it, is that it's very easy to think of that 30% commission not as a commission sort of for the use of the in-app processing system, but rather more like a slotting fee in a grocery store, right? It's basically the fee you pay in order to get to get on the shelf. And that's exactly what Apple's done in the EC. So they said, okay, we'll go ahead, consistent with the EC order, and allow people to use other kinds of processing systems, and they don't have to pay they don't have to pay the commission through the in-app, through the Apple in-app processing system, but they've got to pay a 27% commission on all of the sales that they earn that are going through the iOS. And I think there could have been a very easy, I'm surprised that Apple didn't switch that over to make it more like a slotting fee and de-link it from the in-payment app, the in-app payment system. But now they've done it. Now there's this big uproar saying that Apple shouldn't be able to do that in the EU, and I'm sure we'll see that in the United States too. But I don't see how they can avoid it. It seems to me it's maybe there's something about an exploitative problem under 102 in the EC that the 30% is still too much even as a slotting fee, but in the United States I can't imagine that's a problem.
Hi, my question is, I've heard this take where it's like all the sort of like these novel theories of harm being tested. Like the silver lining is that, it might, like some people might say this is a bad thing, but at the end of the day, we're testing all these theories and the courts will parse through them and then we might, then we can settle them once and for all. So I was wondering, do you think it's a net positive that we're trying all these odd theories of harm, or we're misallocating resources? Not putting, we're ignoring issues that we should be focusing on. So I was wondering, do you think sort of like this new age of antitrust is a net positive or a net negative?
I'll take it. All right. So I think, first of all, I think that the question may have a somewhat faulty premise. When I view the cases that at least are going into litigation by the FTC and the Justice Department, the vast bulk of them are being tried on very traditional theories. Okay, the government is not doing a particularly good job, in the cases, but that's not because that novel theories are being rejected by the courts. It's because the courts have said that even under traditional theories, your proof doesn't meet the standard, and they're being rejected basically because of a failure of proof, not because of a novel legal theory. Now there have been some, and we'll see, and I don't think they're going to go particularly well for the agencies. Like in Microsoft Activision, there was an argument that if you could enter the market, okay, not that you would enter the market in the absence of the acquisition, but if you had the financial resources, basically, which Microsoft had, to develop its own app, that was enough to make out, to make out a Section 7 case, and the California court said, no, it's not. You need to have both the ability and the incentive. They tried that as well. I think you'll see that in Illumina Grail in the FTC's opinion. Unfortunately, that was not rejected by the Fifth Circuit. I, for one, was incredibly disappointed that the Fifth Circuit's decision didn't go up to the Supreme Court. I was fairly confident that you could have 4 votes for cert on that case and that a lot of the bad law would have been corrected. I think in things like the Facebook case, Instagram, WhatsApp, that's just an absolutely fascinating case, right? Because there Judge Mehta is being faced with the question, 2 questions really. So one is, how do you do the tracing that Kristen was talking about, right? I mean, how could you figure out what the path would have been for Instagram and WhatsApp in the absence of the acquisition? And, and the key question there is, would that path have basically with reasonable probability yielded a more competitive space than we have today? And I think the high likelihood on that has got to be there's going to be a failure of proof on that. Okay, even though it withstood a motion to dismiss because it's easy to allege things, I think when you actually get into the case, it's going to be hard. And I think the other problem with a lot of these high-tech cases is the judges are looking and they're asking themselves the question, I'm not a judge, so I can say this, are asking themselves the question, what are the consequences of me ordering, really interventionist relief? Am I going to make things worse rather than better? Okay, and I think that's going to make them hesitant to find liability, but we'll see.
Thank you, Dale. And before I close out the panel, I did want to make several announcements. We're stopping now, and everyone has to leave with their bags. And then you need to go through a check, and you'll come right back in. And we start at 3:45, and the doors will close, and so you won't be allowed in if you linger in late. So, take care of your business out there. Thank you, and thank you to the panelists.
Thank you.